Thank you, ma'am. You can remain seated. Are we ready? Can we proceed?
Yes.
As I've stated, the court will stand by the Criminal Procedure Act and Section 60 that regulates how and what the court must decide when bail is considered. I am not going to repeat the affidavit and all the addresses that was made to the court. It is before the court on record in writing and verbally. I am satisfied that we are dealing with a Schedule 5 matter before court, looking at the schedules as set out in the Bail Act and the charge sheet and the amounts alleged by the state involved in this matter. When one considers then a Schedule 5 bail application, one must look at whether the applicant has acquitted herself of the onus, that it is in the interest of justice that bail be granted in this matter. In order to do so, the court then has to look at the sections of the Bail Act as mentioned by the advocate and state, Section 460, sub 4A to E, and the points raised under those sections, which I'm also not going to read out ad infinitum. It boils down to, and each section starts with the likelihood of whether, if bail is granted, there will be any endangering of the safety of the public and any person, the likelihood if bail will be evaded or trial will be evaded, the likelihood if there will be any influence or attempt to influence any state witnesses or conceal any evidence, the likelihood if released on bail whether it will undermine or jeopardize the objectives of and proper functioning of the criminal justice system, the likelihood whether the release on bail will disturb public order or undermine peace and security. Now, looking at all these factors, the Act is very clear, and Section 8 capital A of the Act has indicated that the court must consider these factors and weigh it up with the evidence presented to the court. The Section 9 of the Criminal Procedure Act regulating is very clear and indicate to the court that the court must weigh up the interest of justice against the right of the applicant in this matter and her personal right to freedom and any prejudice she might suffer if bail is not granted and she is detained. Considering all these factors has been prescribed by the Act, case law that was provided to the court. What is important for the court to consider is also the address of the state in this matter, that the applicant handed herself over to the police, that she is willing, and this is an address from Advocate Kerr Phillips, willing to hand in her passport. The state has addressed the court that they are not opposing her release on bail because she's not considered a flight risk, and the state has considered her health as one of the conditions not opposing bail in this matter. Looking at all these factors and weighing all these factors, the court is then satisfied that the applicant did acquit herself of the onus, that it is in the interest of justice that she be released on bail. Can I hear from the state and the defense shortly with regards to the quantum?
As the court pleases.
Let me give the state an opportunity, Mr. Kerr-Lewis. You've already addressed me to some extent in that regard. Okay.
The instructing attorney called me yesterday and he asked how much bail are we looking at. He proposed 50,000 rand. I said I will ask for 100,000 rand. Obviously this court is not bound by either amount. So the reason I ask for 100,000 rand is informed if one looks at the amount of the schedule, it's 4,550,000 rand. However, that amount relates to the gratifications that were allegedly asked for by the applicant. In terms of our law, that is sufficient. Even if you do not give the gratifications, if you ask for it, that's criminal. However, out of the 4,550,000 rand, a total of 2,150,000 rand was actually given to the applicant by the witness. Based on that amount, 2,150,000 rand, I submit that 100,000 rand would not be unreasonable and disproportionate to the magnitude of the offense. I add, Your Worship, that count 13 is clear. We are charging the applicant with laundering of that money that was received. We know what that money was used for, hence the money laundering charge. I submit that 100,000 rand is reasonable. Thank you.
Thank you. Advocate?
Your Worship, I'm timid to indicate this, but I've just taken an instruction from my attorney. That is not how he remembers the telephone call went relating to the 100,000 rand. Now, I'm not going to be long, Your Worship. The principle about bail is, what can you afford? I think for any South African in the economic climate as it is at the moment, 100,000 rand is unnecessarily high. And what the ground principles, as I understand it, is there's no linear line between it's a lot of money, therefore the bail should be high. Your Worship considers all the issues in my client's affidavit, her assets, her liabilities, the fact that she's now a pensioner, it's common cause, her family connections, and all those things, all the personal circumstances cited in her affidavit, along with the quantum, which is now just an allegation, it's not proof. And insofar as my learned friend submits to Your Worship that it is proved, it is, we haven't had the trial. So in my respectful submission, taking all of those issues into account, the criterion that applies to Your Worship's thinking in my respectful submission is my client a flight risk? Now, I've already commented on my praise for the state in alleging that my client is not a flight risk. They've satisfied themselves from their investigations and from the admissions they've made that my client is not a flight risk. So in my respectful submission, the mere submission, it's a lot of money, therefore she's a flight risk, now contradicts what the state have alleged previously. So it's an issue of what my client can afford. It's an issue on that we were given the expectation that that would be the amount. But those are relatively small weights when Your Worship looks at the issue of the conspectus of facts, all the facts, which point to the fact that my client is not a flight risk. And if those are actually common cause, therefore the amount of bail need not be high because all of them function as an anchor of my client in Your Worship's jurisdiction. So I would accordingly submit that 50,000 rand is ample to satisfy the state that my client sang the trial.
Advocate, can you also address the court, because the Act is very clear that the court must look at the ability and the affordability. Can you elaborate on that with respect to the amount of bail?
Insofar as that is concerned, my client is now a pensioner. That puts her, in my respectful submission, into a special category of person now. My client is very senior. Her earning capacity has now decreased, in my humble submission. And those issues would influence Your Worship's decision as to whether the amount is appropriate or not, as it pleases the court.
Can I hear from the state? Thank you, Advocate. Is there any conditions? You've not addressed me on those points.
Bail conditions,
Yes.
I deal with them now. We do not seek to restrict Mrs. Mapisa Ngagula's freedom within the Republic. No. All we are concerned with is movement outside. That will not form part of the bail conditions. However, it has been discussed with my learned friend that they will bring an application for relaxation of the bail condition in terms of Section 63 for temporary return of the passport, but it's not going to form part of the bail conditions. So we seek that the passport be surrendered to the state. I understand that they did not bring it with them. I would ask that Your Worship orders the applicant to surrender it by 1600 on Monday. What's Monday? It's the 7th. No, sorry, 8th. Thank you. By 1600 on Monday, the 8th of April 2024. They know who the investigating officer is. That the applicant does not apply for another passport pending finalization of the matter. The other usual conditions, Your Worship, that she does not communicate either directly or indirectly, or interfere either directly or indirectly with the state witnesses. The list of witnesses, just like the passport, will be provided to the applicant by Monday, the 8th, by 1600, so that she knows exactly who the witnesses are.
Thank you, sir. Have you arranged with the advocate any date proceeding forward with this matter, and to which court?
This brings me to the next point. I have not discussed it with them. May I confer with my learned friend? It will make it easy
Yes,
while the
you
court
may.
sits.
Yes.
Thanks. I'll back on record.
Just before you go ahead, can we just take an instruction?
Sure. Thank you, Worship.
Thank you.
I place the following on record. On the 19th of March, a search and seizure was conducted at the residence of Mrs. Mapisa Ngakula. Certain evidence was discovered. Further investigation was conducted based on that evidence. I will not disclose anything at this stage. As a result of that further evidence that has been obtained, I emphasize after the 19th of March, I also place on record it is common cause that the defense has brought 2 urgent applications in the High Court, one which was struck off roll on Tuesday this week. So we have been sleepless, so to speak, dealing with those applications and deposing to answering affidavits. So the next move, Your Worship, the state wants to add another accused in this matter. We can add that accused within 3 weeks. However, in consultation with the defense, we have agreed on a mutually suitable date, which is the 4th of June. If it pleases the court, may the matter be postponed to the 4th of June for the state to add another accused in this matter.
And to which court? Would it be court 16?
I'm not from around, I'm from Durban.
Okay, my apologies then. Court 16 is our court that deals with bail applications on a regular and daily basis. And this matter was allocated to that court. We have just made arrangements to sit in this court because there was no court available earlier this morning. So we'll keep it then for record purposes to court 16.
As the court pleases.
Any reply, Advocate?
As it pleases the court, Your Worship, Your Worship, on that day, in addition to having the accused, another accused added, we need to place on record that we will bring, we can do this by agreement before we get there, but depending on how we agree, we're going to bring an application for full disclosure of the A, B, and C sections of the docket.
Of the?
Docket, or the state brief.
Perhaps the state can address the court on when disclosure will take effect, because you have now indicated there's further investigation still.
It's not per se investigations, Your Worship. That is complete. It's just the logistics of bringing the second accused to court. And I place on record that, again, we will be courteous. We would seek that person to be handed over and we come to court.
About disclosure, sir.
Disclosure.
Can we say that this date will also then be for disclosure? For Mr. Kerr Phillips' sake?
We don't have a problem with disclosing on the 4th of June. However, we have a problem with disclosing B and C. So may it be
Indeed.
placed on record that the state undertakes to disclose the evidence, the A clip, on the 4th of June. If they want disclosure beyond that, they've got to bring a substantive application. Obviously not on the 4th.
It is so noted.
Thank you.
Thank you. Thank you. In considering the further addresses in terms of Section 2 capital B sub A of the Bail Act, when the court needs to consider the quantum, it is so that all factors need to be considered. Not only the amount that is alleged, that is in this matter, as stated by the state in the annexes to the charge sheet, but all factors that I've already mentioned in the court, and a balance need to be strived. And again, affordability is one of the questions that the court needs to consider. It is clear that the applicant has resigned. It is not disputed, it's common cause. What her financial position is was not in cents and rands set out to the court, but the court has asked Mr. Kerr Phillips to address the court on affordability, and they have answered that question. The court is satisfied, as I've stated, that the applicant is not a flight risk, that investigation has been done, and that further accused persons might be added to this matter. So the court is satisfied that the amount initially suggested of 50,000 rand is adequate in this matter. The following conditions is however imposed, and that is that the applicant must hand over her passport as requested by the state on or before Monday the 8th of April, on or before 1600 hours at the office of the investigating officer in this matter. And secondly, that the applicant does not have any contact directly or indirectly with any of the witnesses of the state. The matter is then postponed to the 4th of June, back to this court, Court 16. Ma'am, you are warned to be here at 8:30 on that day, should you pay your bail. I'm sure your attorney will explain to you, should anything happen and you cannot be here for any reason, contact your lawyers of record, make arrangements with them, because if we do not hear from you and we do not know where you are, the state can argue and request a warrant of arrest to be authorized and the bail forfeited to the state. Do you understand that, ma'am? Thank you. Court is
Thank you.
adjourned.
Oh,
En Sana, ek het nie my datum stem. En alles is reg.